Hey guys, can you search a crashed vehicle at an impound lot? My name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you a roadside chat from Irving, Texas, and it's been a great class. In fact, I was teaching this topic today on advanced traffic stops. So let me give you some background. An officer has probable cause for a vehicle. The vehicle fled. It was actually throwing dope out the window and all this kind of stuff. And they finally found the vehicle later. It's towed. It did crash, right? It had like an axle that broke. It was towed to an impound lot. The officer wants to search the vehicle without a search warrant. So can it be done? Let's address two different issues. First of all, let's talk about searching vehicles at impound lots. Can it be done under the Fourth Amendment? And the answer is yes. I see a lot of confusion, maybe misunderstanding in this area because, quite frankly, some people are thinking of Carroll and the exigency requirement and so forth. So if you think about Carroll, which is a 1925 case, it essentially upheld that search of that motor vehicle based on exigency, right? And things have changed considerably by then. There was no, the evidence was on the side of the road, the vehicle was on the side of the road in the middle of nowhere. There was no really ability to get a telephonic warrant and so forth. Fast forward to 1970 to a case called Chambers versus Moroni, where the police took a vehicle that they had probable cause for. They took it back to the Sally Port of the police station and searched it at the police station. But here, there was no argument for exigency. And the question is, are we good? And the U.S. Supreme Court upheld that search because essentially there's a reduced expectation of privacy in motor vehicles. So you're going to see from that case on, you're going to see that the Supreme Court moves away from exigency and that the car can be driven out of the jurisdiction and starts transitioning to reduced expectation of privacy. And we also see that reinforced in a 1982 case called Michigan versus Thomas, where the Supreme Court said, when police officers have probable cause to believe there's contraband inside an automobile that has been stopped on the road, the officer may conduct a warrantless search of the vehicle even after it has been impounded and is in police custody, right? Impoundment obviously means impound, take it to a facility. It is thus clear that the justification to conduct such a warrantless search does not vanish once the car has been immobilized. There are also several cases that have directly dealt with cars being searched at impound lots and police stations with no exigency. We have United States versus Ariaza. I'm going to put that in the description. Fourth Circuit, 2010. They say you can do it. United States versus Casaburo, Fourth Circuit, 1994. United States versus Ramirez, District Court out of Kansas, 2016. United States versus Caldwell, 2018, out of North Carolina. You start seeing District Court out of North Carolina. You start seeing the trend here. I also have a case Gastaveros is where the cops searched it 38 days later of the impound lot. The court there said it was irrelevant that the cops did not get a warrant, and it was irrelevant that the car was in an impound lot. All right. So that's where we're at with impound searches. Again, the confusion seems to come with cases, whether it's Carroll or some judges kind of putting in this whole, the car could have escaped out of the jurisdiction type language and thinking to themselves, you know what, the judge is saying that we need exigency here, but clearly we do not. Not under the federal circuit. Now let's talk about whether or not what it matters if the car is crashed and not able to actually move. That changes the outcome. So if you look at some older case law, and it's kind of mixed here, there's some conflict. Some cases say, hey, look, the fact that the car crashed is irrelevant. You still have the motor vehicle exception, but I don't agree with that. The Supreme Court has never addressed that particular issue, but I think that we're going too far there. The Supreme Court has always said that the fact that the car is inherently mobile is the key in there, and the fact that the vehicle is no longer inherently mobile because it has a axle that's broken changes things. And in Mobley versus State out of Georgia, 2019, they did say that the fact that the crashed vehicle cannot be operable, the motor vehicle exception no longer applies. I agree with it. That's what I'm going to teach you. That's what I think is making good case law, and predictably, I think that's what the Supreme Court's going to say. My final few words on this. Number one, this is not the rule in every state. If you work in New Mexico, you work in Pennsylvania, you work in New Jersey, you work in Washington, you know that you can't search cars at impound lots. So the other thing is, just because this is the law doesn't mean this is what we should do every time. Just because you can doesn't mean you should, right? So what I'm going to teach you is, if the car's at impound lot, especially for big cases, go get that warrant. It makes good case law. It reinforces good case law. The judges like it. You like it because it actually helps your cases in the future. You have easier days at court. You're not under the gun, and on the ropes about why you did it, and maybe some prosecutors don't understand that it could have been done. So maybe they dismiss your case, et cetera, et cetera. Let's make good case law. It's worth it. All right. But that is your answer. Again, I will put all these cases, it's a little bit long, all these cases in the description. So for you to read, if you want to read yourself. If you have any comments, if you agree with me, let me know. If you disagree with me, let me know. But that's what I have for you. If you like at least moving the conversation forward, hit like, subscribe, comment, share with your friends, and I'll see you guys next time.